this afternoon.
Before I start, I'm sorry, I'm sick, so if my voice cuts out at any time here, I'm just going to cough a lot and hopefully it'll come back. Okay, is everyone good? Okay. Honorable Speaker, the justice system is indivisibly split along the wealth lines of what kind of counsel you can afford yourself. Recognizing that wealthy people have extra tools within the judicial system that give them unfair justice outcomes. The ability to hire lawyers who simply have more information, more time, more precedent, and more ability to seek experts to help you with your case. I think in this case, the state recognizes that the people who cannot afford these extra privileges have some kind of right that ought to protect them against manipulation and against information asymmetries that are likely to put them in a more harmful position. Recognize, though, when that is not an issue, when you do not need to protect yourself against those information asymmetries of the state, because you are doing so in an additional way by hiring somebody who solves those for you, we think that this then opens itself up to strategic abuse by allowing the wealthy to protect themselves twice over, firstly through better counsel, and secondly through not allowing this information to be made public. So for this reason, this House believes criminal defendants who hire private counsel should not be afforded the right against self-incrimination at trial. I think we understand what this means. It's two things, the right not to testify in your own defense and not to answer incriminating questions from the prosecution. So should you hire private counsel, those two things will not apply. So, not yet. So why does this right exist? I think I've explained this in my introduction, but more extensively, it's against the manipulation of justice and against unfair incrimination, which we think happens because of a lack of information and a lack of interest by the defendant based off of their based off of their lawyer. So if you have private counsel, this is evened out and takes over for this right, recognizing that this right is not a fundamental right, but an instrumental right that has been created by the state to try and protect for that. So what kind of two benefits do we think we're going to get? The first one is about information gaps. I think this is going to be particularly important in issues of public nature. So for things like corporate law and things like finance law. So information we think in these cases, for example, white-collar crime, things like Volkswagen, things like issues that deal with the public on the day-to-day, information that comes out of these trials have benefit beyond just the outcome of the trial and beyond just who is innocent and who is guilty, but do things like set precedent, do things like have public impact, do things like influence what kind of trials take place in the future. We think in this sense, it's hugely harmful when these companies, we are assuming, are going to take private defendants anyway because they believe they're going to be able to get better outcomes. But when these people are also able to hide behind a shield of not answering questions and being able not to provide information that is not only in their own defense but for the benefit of the state, we think that this has major problems for the safety and security of the state and the people who live within it. So in terms of corporate law, I think the two benefits are, first of all, that you get information going on to public record and information that's going out to the public that then becomes beneficial. Secondly, though, I think this means that there then becomes more media attention and more media coverage, so then that proliferates and that expands. I think this is also very important for issues of finance law, specifically because this means that there are so many loopholes and tangles that it becomes very easy for people to hide behind this right. Yeah.
Do rich people all of a sudden not have the right to remain silent when they're arrested?
No, because I think that's a different part of the justice system. This is trying to solve for what happens within courts and what happens specifically about the manipulation of information and the manipulation of justice. So secondly now, let's talk about what happens in terms of the trade-off people are going to make. So recognizing that I think the choice between a public and private defendant right now rests on the assumption of what finance you can afford. So if you do not have that choice, you take that public defendant and you keep the right, which we recognize is an imperfect tool, but solves in some ways for the barriers you are likely to face. So the barriers of not having enough time with your public defendant, the barriers of perhaps not being able to choose somebody who you feel like you can relate to, feel like you trust, feel like you have language or other ways in which you trust that public defender. So recognizing those are barriers that cannot be overcome, Why do we enshrine this right? Well, we give it to you as a right because that means it's enshrined, and it can't be removed by political whim. So I think that's the reason that we afford this right specifically to the people who are most likely to be vulnerable within the justice system and are most likely to have the political system try and remove rights from them within the justice system itself. So then secondly, though, if you can afford, I'll take you in a little bit, if you can afford the choice between a private and public defender, what happens? I think now you make the choice based off of what information you think is going to be self-incriminating. So the real people this is going to do is a trade-off regarding your assumption of guilt and whether or not you believe this guilt to be indefensible. So the real people we think this is going to force to try and take on public defenders is people who are wealthy but scared about the level of guilt and scared about the information that they know and are able to receive. And we think these are the kinds of people who are most likely to get off under the system on status quo, because not only can they hide behind manipulations of the justice system, they can hide behind not giving out that kind of information. So two impacts. I think then if they feel that they must choose public defense, because to choose private defense and give up that information would be an admission of guilt, I think there is going to be necessarily some lobbying for public defense, recognizing that these people have immense power and probably want to influence the justice system in some kind of way. I think that, yes, indeed, this does help those kind of people in some way, but currently there are absolutely no advocates with any kind of power lobbying for additional power within the public defendant system, because nobody has to make that choice right now under status quo to take those public defenders. So on our side of the house, when you necessarily force some people who have power, who have impact, and have money to make that choice, you insert advocates for that system in ways that simply do not exist under status quo. So on the comparative, you get better outcomes. Sure.
If you wish to push people towards public defense, why not ban private counsel altogether?
Because there is a trade-off between information and rights for people who simply, about the information stuff that I mentioned before, that I think gives you an additional benefit that you're able to solve for. So this means that without this right, you are going to get better information. So secondly, though, I think it's important because it illustrates issues of information asymmetry that I alluded to prior, and I think that that simply sheds more light on the justice system and the issues that exist within it. So because Julie and I believe that this simply gives the wealthy extra tools to get unfair justice outcomes, we're incredibly proud to propose.
Yeah, thank you, Prime Minister, for the remarks, and invite the leader of the opposition to take the case for this.
Mr. Speaker, if I'm on trial for murder against the state and want to have the best possible lawyer, but don't have faith in my own ability to speak to my experience, to speak to my innocence, I shouldn't be forced to make the choice between a public defender that will not work in my best interest, that, as I'll tell you, cyclically treats individual cases as secondary to their job, to their purpose, and why they treat them less effectively than private defenders. But I think that you shouldn't have to make that decision between that or self-incrimination. So I'm going to talk to you about three things. Firstly, why this doesn't solve for the imbalance that government wants to impact. Second, how this harms the system that we're trying to preserve. And third, the ideals of the criminal justice system, how this undercuts them. First, some rebuttal to Julia. So Julia's idea is that companies hide behind the shield of lawyers such that information is never available. She talks about the information gap. We see this is not true to reality, especially in the cases of companies that she brings you. So on face, we have subpoenas and the use of outside experts that speak to the technical actions of companies and that bridge that gap in technical difference, right? That it is the purpose of prosecution to bring outside experts, and to subpoena through the court system in order to get this information to provision to those that are on trial. Secondly, I think CEO rightly points out that why, if OG has all these problems with private defense in the first place, it's something that should be provisioned and should be allowed for those that are going to have access to it. And we think that all of the harms of private defense, as I'll bring you in my constructive, still exist. And in fact, this is at best, mildly mitigatory action, not something that actually impacts the system. So why is this? Why doesn't this solve for the imbalance? So firstly, rich people that hire capable lawyers are still able to manipulate the system in spite of this provision. How is that? Instead of being given the option to not speak at their trial, they are now still privy to all of the legal maneuvering and better information and better access to how to work the system that are given to them by better lawyers. So now, rather than not speaking at their trial, they perhaps are asked to speak at their trial and say, I don't recall. And this difference is arbitrary and in fact negatively impacts people that are at the margins, that are perhaps on trial for something that might take the rest of their life away from them, and they ought to have the right to get a better lawyer if they want to pay for it, if they want to decide that that's something that's important to them to put their money towards. Under their side, this option is less available to them. So second, state-offered counsel for public defenders is still terrible. Why is that? So the problem with public defenders is that each individual court is given a certain number of cases per year with a severely limited number of public defenders, right? They're allocated sets of 50 and 60 cases at a time, and wherein they spend 5 to 10 minutes with each individual defendant and then have to decide on the basis of that meeting whether or not they will proceed to trial. What does this look like? It means often they choose not to proceed to trial at all. So these public defenders say, you're on trial for a weapons charge, you likely won't make it to court, you likely won't make it in court. We think that in the instance that you're going to instead be found guilty by a court, that outcome is much worse, therefore you should take the deal, take 2 years, and get out of here, right? We think that this provision doesn't stop any of that from happening, and it doesn't change any of the imbalance that exists against those individuals. We think that your public defender, in those 5 minutes, making that decision on whether you are guilty or not, is the greatest breakdown in how people are allocated different levels of justice, and that breakdown is problematic that they don't solve. Go ahead.
Okay, so recognizing that there's still a number of people on your side of the house who are forced into using these apparently awful public defenders, why don't we mitigate that gap in justice at least a little bit on our side of the house?
You don't mitigate that gap in justice. Bringing other individuals down that are at the margins to the level of those that are having to deal with public defenders now doesn't solve the problem. We think that if you want to change it, you could likely ban private counsel, improve current systems of public counsel. You don't do that on your side. We don't understand the nuance of your case. So second, how this harms the system. Firstly, the standard that this sets is harmful for those who are at the margins that can barely afford private counsel or afford only moderately trained counsel. So they now default into the public defense system that opening government agrees are bad, that are worse than the alternative, which we told you in Constructive as well is much worse. And it consigns them to more time in jail, harsher fines, and the worst provision of justice. So this is made cyclical when criminal offenses are impacted more harshly on those that are at the margins, that are poor, that are either going to be entered into these trials where they're predetermined by their public defender that they should not go to trial because they don't have time to provision those services to them, or they end up with an individual that is or they have to choose between an individual that they can afford while losing their benefit to not the benefit of not speaking on their behalf and consigning themselves, self-incriminating themselves. So this choice is no longer a choice unless you are very rich and can afford a very good lawyer, right? So the gap between choosing to self-incriminate or having someone that can defend you means that you only choose a lawyer when you can afford a very good lawyer, so it preferences those individuals that have more money, right? So second, it creates a system in which poorer defendants are presumed guilty based on uneven application of justice. So when you are given greater options, when you give greater options to poorer suspects, you create a narrative that those that go to trial and win because of this special treatment, because they're opted out, because they didn't pay for a better lawyer, right? So this compounds and extends the harms that we see now, where these biases still exist, right? That a trial alone equates to guilt, and that society treats them as guilty because they went to trial. This is impacted more especially on the poor that carry this stigma. I'll take a few out from CG because I have to stay too if you have one.
Yeah, so most cases don't go to trial, and most people can't afford private counsel in the first place. Like, why is this typical example you're relying on of the poor defendant, like, actually what the round is about?
That's exactly what I'm telling you. That people usually can't go to trial in the first place when they have public defenders. And they usually can't afford private defenders. So this case doesn't impact the groups that you're trying to help. So third, those that are societally biased against now have a greater likelihood to lose trials and get convicted. So lawyers may reasonably choose not to have their defendants speak in their own defense because the juries to whom they are speaking might be biased against them. So members of ethnic minorities in a given state where racial biases are very strong, maybe women that are more likely to be seen as distrustful based on sexist societal norms, or even the mentally ill that might not be able to speak competently on their own behalf. Now, to choose between having a reasonable, strong defense that they pay for or self-incriminating. But so third, the ideals of the criminal justice system and how this undercuts them. So first, the ideal is to create a circumstance in which defendants can defend themselves more effectively against the state. Why is this? The reason that we have this law, we have the law and the status quo, is to protect individuals against a state that is better equipped and better positioned in the legal system. such that they can receive the best possible outcome from their trial. We see that public defenders in the status quo do not do their job as they're supposed to, but this provision does a worse job in provisioning resources to those that are at the margins. It does a worse job in accessing the harm that they're trying to incite government. We're very proud to oppose.
Thank the Leader of the Opposition for his remarks. I invite the Deputy Prime Minister to continue the case for his side.
Okay, I think the Leader of the Opposition is correct in that he didn't quite get the nuance of Julia's case. Here's the basic idea. Generally, I think it is incredibly important to recognize that having a private defender affords you a ton of privileges in the justice system that having a public defender, excuse me, I'm also sick, doesn't. And we heard this articulated sort of clearly out of the Leader of the Opposition. Why is this important? Because now because under status quo, there is an instrumental right to prevent against self-incrimination. The purpose of this, as Julia explained to you, is to solve for a procedural asymmetry of information to prevent you from screwing yourself over when you don't understand how your comments are legally interpreted or the ways in which they can incriminate you in court when you don't have enough information about how the justice system works. That's why you have this right, so you don't accidentally get manipulated into saying something that screws you over because the state is abusing that asymmetry of information. That isn't a problem for people who have a private defender who can advocate for you by navigating the legal system on your behalf. So you don't need that right if you have a private defender that solves that problem in a different way. So I think when we afford this right to people who use public defenders, who are more likely to be less effective, who are less effective at advocating for them, I think that they need that to protect against that risk. That is not true in the case where you have a private defender. I think that solves for the concern about people on the margins. They still get the advantages of having a private defender. Also, I just think the harms that we heard articulated to the other were pretty hyperbolic in the sense that he has equated this with automatically being judged guilty. That's not true. It simply is the case that you have to disclose much more information, or some more information, about things that only you as the defendant know about. I think he glossed over Julia's example of corporate law and finance law, but I think in cases where there is significant public interest in knowing what the evidence is, and the actor who is on trial has a significant amount of evidence that simply isn't available through, for example, external expertise, and often I think it's publicly important this be disclosed, I think we actually get a lot of cover-ups and a lot of sort of equivocation about, first of all, just trial outcomes in terms of guilt, but second of all, just information about what happened in the case of, I don't know, Ford, Pinto, or Volkswagen, and that's information that we usually think should be disclosed as long as it isn't a risk that we have this abuse that happens in the public defenders. So I think he did sort of miss the nuance there. Actually, I'll take a POI from either. Let's go.
Why not subsidize private counsel or improve public defense rather than harming individual defendants? Okay,
obviously we also want to improve public defense, but that's not what we're solving for here, right? We think the problem is a lack of information when this right gets abused by rich people, and I think we solve for that uniquely on our side of the house. I think just saying that you could either ban private counsel or subsidize public defense just addresses a different problem, maybe also subsidize that. But also Julia talked to you about why we actually get better political advocacy for improving public defense on our side of the house, because now there are some rich people who feel that they might choose a public defender if they don't want to give up the right to self-incrimination. For example, if they're pretty sure that the evidence against them looks pretty bad and don't want to self-incriminate, then I think they have an incentive and an investment in improving the system of public defense. I actually think we get significantly better advocacy for that improvement on our side of the house. I mean, it is an op to say we would just solve this instead. We've given you a mechanism for why it is better on our side of the house and why that asymmetry becomes a little bit more even. What did we hear explicitly out of the Leader of the Opposition? This doesn't solve because rich people are still advantaged, so you could just repeat, I don't recall. Okay, a couple of things. This does not solve for all the advantages that you get, the asymmetries between having a private and a public defender, but I do think it makes it slightly more even in the case that you have a private defense, a very well-paid, for example, corporate lawyer who's very good at manipulating the tools in their toolbox to get you the outcomes that you want. I think that the vast majority of the time, they're able to let you plead the fifth strategically such that you can cover up much more information and get probably less just outcomes in terms of getting off easier. That's not a thing that we like. We think that this is abused by private defense in a way that is much much less likely to be by public defense. So it doesn't solve for all those problems, but it does take away one unfair advantage that doesn't lead to just outcomes that is afforded only to the rich under status quo. We think that's a good thing. Okay, state counsel is really, really bad, and he told you a number of reasons why public defenders are just the worst. Okay, so I think often public defenders are adequate. So he talked about, his concern was that you would have to make the trade-off between a basic right and adequate defense. Julia told you why this isn't a basic right, it's actually an instrumental right. And I think public defenders, much of the time, are adequate, although less good than private defenders. I think they were less good at strategic manipulation, but we stand on our side of the house that they are often good enough that this is an okay choice to make people have to make. I think if you choose between defending your right to self-incrimination and picking a public defender, public defenders are good enough that that is like a legitimate choice to make people have to make, and also I think they get better because the rich people now know that there is some investment in improving that system. So I think that was a little bit hyperbolic as well. Okay, his second concern was that there are these marginal people who do pay for private defense, but the private defense is only kind of good, but then they don't have the right to protection against self-incrimination. His concern is that those people get sort of the worst of both worlds. First of all, I think this is the minority of cases. I think that even not particularly rich private defenders are still good enough that they could sort of account for this asymmetry. But second of all, I just think we'd be really careful about informing people about what kind of rights they're trading off, and that's a choice that is perfectly legitimate to make people make. If that pushes more people into public defense, that simply adds to the political will to improve the public defense system. I think that's probably a good thing. He told you poor people are biased against because now it looks like a trial alone equates to guilt. I'm actually not sure why this changes on their side of the house. I think, and also I think that insofar as you still can't lie on the stand, right? I still think that we generally only get more truthful information about these circumstances of whatever happened for which people are on trial. I think that's overall a good thing, and if a trial equates to guilt, it can only be because someone is overwhelmingly guilty enough that any speaking on their own behalf would amount to self-incrimination. Yeah.
Should those on trial using private defense be presumed guilty until proven innocent?
Yeah. I don't think that changes. Yeah, I think that's true. I've explained to you why this right in particular is instrumental in one specific way. Oh, the other weird sort of equation that we heard on first opposition was about whether or not you still have the right to remain silent when you're arrested. Absolutely, because at that point you don't have a lawyer who is manipulating the system for you. This is what that solves for, and the private lawyer fills in that gap in a way that it doesn't at the point at which you're arrested. So that's where those things are different. This is a very specific right that serves a very specific purpose. That purpose doesn't need to be solved. Doesn't need to be served for people with private defense. Okay, what did Julia tell you and why was it not responded to? She first of all explained that in great detail, out of which we got just no response, except rights should probably be equal. We told you why this is instrumental and doesn't need to be equal across all cases. Also the fact that, conceded, the justice system is incredibly uneven under status quo. Given that it is more even on our side of the house, I think it was not sufficient to just not respond to that point. Second of all, she told you about information gaps. Why, when there is a public interest in filling some information, sometimes that information can only be got by having the person, or the corporation often, who is on trial, speak for themselves to what happened. I think usually people or corporations plead the fifth and end up not disclosing a lot of this information about which there's a pressing public interest. That is a bad thing. In response to this, we heard that outside experts can solve for this. That's just implausible. I think there's a lot of information about what Volkswagen did and the chain of information that happened when that case happened that only they can speak to. I think it shouldn't be the case that corporations can get away by paying an incredibly rich and talented lawyer to allow you to manipulate this right in that way. We are very proud to propose.
I thank the Deputy Prime Minister for remarks and invite the member of opposition to continue the case for a second.
So the greatest impact that I can understand out of the opening government case is that sometimes the public will have more information about VW, but I have no information about who will and who won't go to jail, who will and who won't be found guilty, and why there is necessarily more justice on their side of the house. In fact, what we tell you in opening opposition, that there's far less justice on their side of the house, where in fact the criminal trial and the criminal proceedings of your court case are invalidated by laws that mean that who you are when you enter the courtroom determine how the justice system applies to you. I think that principally this means that the results of court cases are less valid because when you get off as a poor minority person in court, the public is able to assume that the reason you got off is not because you are in fact innocent, but because nobody asked you to testify against yourself. You were able to hide information in the courtroom, and because of that you were able to get off scot-free. That means that when you try to re-enter society as an acquitted poor person, you are far less able to do so because your trial is deemed as invalid. And when you are a wealthy person who goes to prison because you were forced to self-incriminate, we think that that process ultimately reflects that the justice system was too harsh on you, right? That the public now believes that wealthy people who go to prison because they were able to afford private counsel aren't there because they actually deserve to be in prison, but because the justice system is cracking down on them more than they should be. We see this as an analogous case to the reasons why people criticize affirmative action, right? You don't deserve to be in college if you're a poor minority because someone helped you get there. Just the same as the success of a person, or the reason wealthy people are in college is not in fact because they deserve to be there, but because they have a lot of money. No. Okay. A few points of rebuttal before I get into two extending points and reframing Danny's points as well. So one, how does this change the framework of the justice system? I've already prefaced this. No. But two, why does this right exist at all? And why is it necessarily that this right exists uniformly across the justice system? Okay. But first, a couple points of rebuttal. So first, this idea that knowing the evidence matters in society. Okay, so maybe the trial records of corporate law cases and tax law cases and financial cases should never be sealed. But the asymmetrical application of justice means that certain groups are preferenced and certain groups are viewed as victims. Also, this idea of rich people will choose public defenders, I haven't heard sufficient analysis in opposition why rich people would willingly buy into a system that they know is broken in the hopes they wouldn't have to self-incriminate. I think that there are far greater concerns they have when they go into a courtroom. One is that the demons of their past will be revealed to the public. That's far more concerning, and they would rather have a lawyer that is able to hide those things and never get to trial than to have a public defender who will probably screw up their case opening.
That's only sometimes true. I think there are a lot of rich people who are concerned about their lack of ability to not self-incriminate, who then would be forced into choosing public defense, or at least who feel that is enough of a risk that it's in their interest to have a robust system of public defense.
Okay, so maybe there's two rich people that choose that they want to be in the system. But we don't think that's enough to create political pressure, and we don't think this analysis is efficient, that there's political pressure to push for changes in public defenders. We think that it is true, and we also support the closing opposition claim, that we would far prefer a world in which nobody is allowed to choose a private defender, and you are better off in a system where everybody is forced to buy into public defenders, and therefore make that system better. No. Okay, but finally this idea that that people strategically plead the fifth when they want to get off. So I think this probably happens sometimes, right? But the most important impact in this case is not, in fact, how rich people are treated in court, right? Because what this attempts to solve for, what are they trying to do here? What they're trying to do here is they're trying to fix an asymmetry of justice. But we posit on opening opposition, this asymmetry of justice doesn't occur at the point at which you are on trial, right? It occurs long before that. It occurs when you've been economically disadvantaged and disadvantaged in the location in which you've had to live for your entire life, such as you were more exposed to crime, such as you weren't given an adequate education, such as you weren't able to get a good job, such as you felt that crime was the only option for you. Or ultimately, it's because the police are racially profiling you and they've arrested you simply because you were in the wrong place at the wrong time, right? I think there's nothing to solve that kind of problem. And that's why when I ask a POI about, do you still have the right to remain silent when you're rich, there's a principal inconsistency in their case, right? Because if it's true that wealthy people are preferenced in the justice system, but that preference originates only in court, then that means that these wealthy people should probably be afforded the same, removal of the right to remain silent when they're arrested, right? Because they're already going to be prefaced when they get to court. We think, I'll take back half in a second, we think that is also inconsistent. So I'll take you before that.
So on your idea that now the poor look bad because they're the only ones who can plead the fifth, they can still choose to testify if they want when they're concerned about that perception.
Okay, so this idea that people who choose public defense have absolute choice about what happens in their court case is false, right? Because when I'm a public, this is my first point, which is how does this change the framework of the justice system, right? Because what it means is that there are certain groups of people who have different rules applied to them when they go into court, right? So what this means is that when you're a public defender, when you're one of 75 cases that they're dealing with in one moment, they have 5 minutes with you in your jail cell, right? And while you're being held. And when the questions that they ask you are not in-depth questions that a private defender might be able to ask you. They're cursory questions. And in this 5 minutes, they decide whether or not they think you're able to proceed to trial. They don't ask you, do you want to proceed to trial? Maybe they ask you, but ultimately what they're deciding is whether or not they think they can win, whether or not your case is worth their time, weighed on balance with all of the other cases that they have in their docket. So ultimately what happens is you don't get the choice of whether or not you testify, because your public defender tells you, no, don't say a word, because I don't want to deal with the fallout when you incriminate yourself on the stand. You don't have that choice ultimately. Public defenders are able to file suits that remove legal rights from their clients, and that means that people have less choice when they go into the courtroom. So the reason this right exists at all is because we think that when the state charges you with a crime, there already exists an imbalance of power, at which the state will always have more information about the laws than any private individual, right? So even if you have a good lawyer, and there's a lot of instances in which you have a bad private defense lawyer, right? We think they're not all good, they're not all incredible, they're not all Johnny Cochran. So what this means is that the prosecution always has an imbalance of power. So you as a private individual who is going up against the full force of the government must have some right to protect yourself from the invasion of that government into taking away your other rights, such as your right to freedom and your right to free speech and your right to do what you want with your life, which they take away from you when you go to jail. So this means that we need to protect all individuals, particularly those marginalized groups that Danny told you about, who might be able to afford a private defense attorney, but ultimately are harmed by other institutionalized systems, such as racism and sexism, in the system. We think that it is far better when we apply the justice system equally to everyone, and that is why we oppose.
Thank the member of opposition for remarks, and invite the member of government taking the case for closing arguments.
Because the problem with opening half so far is that it's been wildly hyperbolic. We will fix the public defense system, or suddenly all poor people will be seen as getting away just because they have access to the Fifth. What we're going to do in our speech today is ground this in the context of where this motion is most likely to play out, and why specifically in those cases we think this policy is crucial in order to have any measure of accountability within the criminal justice system. So what are the kinds of cases structurally that this motion requires us to talk about? Recognize there are three things that the motion points out happen in these cases. The first is that these criminal defendants have the ability to hire private counsel. So it presumes the ability that these people have the kind of money required to hire private counsel and not rely on the public defense system. Secondly, that these things have gone to trial already. We think that this is why this debate isn't about the vast majority of what OO wants to talk about, because the kinds of cases that poor people are often in are things like drug possession, things like low-order crimes, which rarely go to court at all because plea bargains are struck long before that stage, and because of the fact that these people aren't required to testify in most of these cases. The third thing that we think that's pointed out under the motion is that these rich defendants are pleading the Fifth. In lots of cases, we think rich people choose not to plead the Fifth. Consider, for example, the case of Hugh Labrie, a guy from Phillips Exeter, an elite high school who has been charged with sexual assault. He's the kind of dude who goes up to the courtroom and plays into the optics of being someone who's responsible, who's cooperating with the jury, and who's being someone who's a responsible citizen. We think in these cases, people are much less likely to plead the Fifth because the optics in that situation are incredibly important in convincing the jury that you're a good person and that you're someone who is working with the law in order to get a fair outcome. We think that's the second reason why it's not likely to be about the kinds of cases they're talking about. Because even if poor people are in court, we think these are the people who are most likely to not plead the Fifth. Because we think juries who already have racist and classist biases are going to be even more likely to think that a black dude who's continuously saying, I refuse to answer that question, is probably guilty because he's not cooperating with the law and clearly doesn't care about a fair outcome. So we think these are much more likely to be about procedural trials where there are strategic reasons to plead the Fifth. What is the conclusion of these three things? Rich people, the fact that it's gone to trial, the fact that it's procedural, means that the vast majority of cases where this is likely to happen are things like white-collar crimes, things like financial and corporate crimes. We think OG recognized this. We give you the structural reasons why that's true. But this is where we go even further than OG. Why is it crucial in this situation that we get rid of the right against self-incrimination in order to get any sort of accountability within these cases? A couple of reasons why structurally these cases require this. The first thing we're going to say is that these kinds of crimes often don't have other witnesses other than the defendant who's put on trial. If I'm the person in charge of creating the financial structure of a firm, and I've structured it in such a way that I'm quietly sending some money into my private account, I'm often not going around telling other people in the office, hey, you know what I'm doing? There's $500,000 extra in my bank account every week. It's quite likely that this is the only person who knows it, and therefore the information that they provide is particularly important in being able to reach any sort of conclusion in this case. Second, even if other witnesses exist, we think it's often hard to find because within the corporate structure, these people have sophisticated things to do, like covering up email chains, things like even when communicating, not doing it in a way that's easily accessible, which means even if other witnesses exist, they're hard to find, and therefore it's not something that can come that can come to a conclusion easily. This is where we think OO actually has some good material. They say, but rich people will just circumvent this, and there's other ways of getting this information. Let's look at the particular ways in which they said it. The first thing they said was, now lawyers will just train rich people to say, I don't recall, instead of saying, I plead the fifth. Let's recognize what an absurd claim that would be. If a defendant is standing up there and saying they literally don't remember anything about the time in which they committed the crime, it means that the rest of their evidence, anything else they testify, is going to come under direct, because it brings into question directly the veracity of anything else they claim to remember from the same period if they have these gaps in their memory. No, thank you. So we don't think that that's a likely outcome at all. What else could be an alternative, right? So my CEO might come here and say, oh, but lawyers might just train these people to lie or like bend the truth in these situations. Why do we think that's not likely? First, because lawyers have a massive incentive to not do this, because they would literally be disbarred and prevented from ever, no thank you, practicing again if they train their defendants to lie. Second, because we think lies are generally easier to spot. If someone keeps saying we plead the fifth, it's hard to contradict the fact that they're pleading the fifth. But if someone is lying on the stand, we think it's easier to bring into account, no thank you, to possibly try and look for other people who could contradict that. No thank you. The final thing they say is, oh, but you can just, I'll take you in a second, we can just subpoena these people for their information. Go ahead.
Why don't we just hook criminal defendants to lie detectors to ensure they never actually lie in the way that
No, because lie detectors hardly ever work. They've been systematically proven to be awful. That's a bad extension if that's where you go. Subpoenas, right? They say we can just subpoena these people for the evidence. Two reasons why this is an insufficient answer to the lack of accountability that rich people within the financial sector face. First, because if they're concerned about legal loopholes, subpoenas are one of the places where legal loopholes are massively used to get away with it. Saying things like, we can't actually give you this document because it's a confidential document between us and a client which we're not eligible to give away. Doing things like when asked for an email, sending over hundreds of thousands of email communication between people so that this already burdened public prosecution system, and this is the other bit of material I'm going to add because everyone's interested in talking about public defenders, no one's interested in talking about public prosecutors. I'll talk about that in just a second. Sending hundreds of thousands of emails to the public prosecutor and saying, go through all of this in your own time and try to figure out the one email where we kind of hinted at the fact that we're engaging in money laundering. You guys make that so much worse. In comparison, why do we think our alternative is much more likely to get accountability? Because in the process of questioning, when you have a person on the stand and you're directly questioning them, you're bringing into the court experts, and you're engaging in this kind of back and forth, it's much harder for them to get away with the kinds of lies and legal loopholes that they might have gotten away with when they have an infinite amount of time to prepare with their lawyer, right? Because on the stand, it's just them and the other lawyer who's questioning them. We think in these situations, and this is the second answer to the subpoena argument, is that often at the outset, people don't know what the questions to ask actually are, because the facts of these complicated financial cases come out over time during the course of the trial when you're engaging in this questioning. This is where public prosecutors come into importance, right? Because public prosecutors, we think, are currently massively overburdened, just as a lot of public defenders are. Even if at the highest levels it might be less likely to be the case, in general we think this is the case. And also these people often have access to less technical knowledge than these lawyers do, than these people do. That's why it's important to not give these guilty people infinite amounts of time with their lawyers, and instead put them on the stand and require them to answer questions at court. This is the only way to hold these people accountable. Incredibly proud to propose.
Right. I thank the member of government for the remarks. I invite the member of opposition to open the case for the closing opposition.
simply really arrogant to assume, as the entire government does, that there is a single outcome that can and will serve the public interest. I think that's the whole basis behind why we have an adversarial legal system, because we understand that there isn't exactly one outcome that we can always confidently say will be good, and therefore we should always decide cases in that particular manner. I think the reason we have an adversarial legal system is because we understand that everybody in some way has a fundamental right to, first of all, what's in their head, which is going to be one of my points of extension, and second of all, a right to self-defense against the arbitrary powers of the state, another extension. Before that, I've just got 2 points of contention against the entire government. The first is the opening government, when they talk about rich lobbyists and how pushing rich people to public defense systems is automatically going to improve the public defense system. First of all, I think my partner just POIs them, and it's like, why don't you ban private counsel altogether? I think that's maybe a more efficient way to go about what they're doing. But second of all, and I think this is a more compelling argument, the point of criminality is that you never think you get caught. Under the cost-benefit analysis that an individual makes when deciding to commit a crime, the weighing here is that the risk of you getting caught will always be lesser than the benefit to you of carrying out that crime. That means you are unlikely to project 20 years into the future when you are a young underling and Goldman Sachs and realize, maybe I should start investing in the public defense system now, just because so when I start embezzling, something good is going to happen to me. I honestly don't think that's going to happen. The second point of contention I have is about pressing public interest and evidence. I think that a focus on public interest just leads to scapegoating, more on that later, but more importantly, I think that this, like an entire gov bench's case could just easily be solved by like a mandate to maintain greater transparency of evidence on both sides, both prosecutor and defense, right? Like, I don't understand why this need requires a violation of individual privacy to get the kinds of outcomes they want. You don't necessarily need to compel private info to get the kinds of outcomes. Second of all, closing government tries to extend this by saying, well, this just means that people will dump a ton of emails onto the public prosecutors. First of all, I think in the kinds of cases that both opening gov and closing gov are talking about, these are the kinds of public impact cases that will probably have like tons of people sifting through evidence there, right? So this harm is just about mitigated. But second of all, I just don't buy that this is only about white-collar crimes, regardless of the analysis that closing gov gives us. I think this is also likely to be about things like heads of drug cartels or people with money who are like upper middle class and can afford some form of private counsel and thus eventually go to trial. I think in many cases, really rich people in the kinds of crimes they're talking about very often try and settle through private arbitration. So no, it's not only about white-collar crimes, and a lot of the analysis doesn't apply to the vast majority of cases we're going to be talking about. So 2 extensions for you today. First of all, about procedural versus outcome justice, and why it's crucially important that this is in line with the right to self-defense that we accord to every individual. And second of all, I want to talk to you about the right to self-incrimination and why we never ever punish people for thought crimes. First of all, procedural versus outcome justice. I've already told you that the point of the law system is to preserve individual rights rather than to just set an example for the rest of society. Because if that were true, then we would simply scapegoat every individual criminal and set unnaturally harsh punishments for certain crimes just to ensure that we don't have those crimes carried out in the future. I understand we do this now. I think a broad majority of us agree that this should not be happening and we should move away from it. Okay. So why is this particularly important when viewed in light of the right against self-incrimination, not discrimination? I'm sorry about that. This is an extension of the right to self-defense, right? It's not necessarily that you have no way out other than resorting to private counsel. It's about whether you perceive that there are reasonable alternatives available to you at that point in time that you will be able to partake in when you decide to make the choice about opting into private counsel versus public counsel. And I think there are many ways why this perception is skewed in favor of you opting into private counsel. First of all, prosecutors just have an unfair advantage, right? CJ wants to talk about public prosecutors, let's talk about public prosecutors. They're able to dictate both the charge and the punishment. Very often they're able to dictate huge bounds on the limits of your autonomy and your freedom in terms of when you're called to call the punishments you're likely to get, what questions you're compelled to answer. I think for the kinds of high-profile crimes they're talking about, the DA office also just has really well-paid public prosecutors that they are likely to assign full time to these cases. Very often, multiple of the best public prosecutors working together for these like public interest crimes they're talking about, right? So you also have the kinds of experts and the people that sift through massive amounts of evidence for you, which means it's a greater imbalance than ever between the kinds of public prosecutors they want to talk about and the kinds of public defendants they want to talk about. Because recognize, even in these kinds of cases, the public defendants themselves are always going to be overworked and never going to be able to dedicate the full amount of time to your particular case, even when the public prosecutor is able to dedicate all their time to it. So we think there's a massive imbalance there. What else is bad about public defenders, right? I think it's a reasonable cost calculus made by an individual to know that having a bad public defender doesn't just mean they get the punishment that government thinks they deserve. It means it's a high chance they get a larger punishment than their crimes could possibly account for. Because a poor public defender doesn't just ruin your shots right now, they ruin your chances for the foreseeable future and the kinds of punishments that accrue to you, and we don't think that's fair. Therefore, as an individual, you have the reasonable right when you believe that your options are so poor to opt into private counsel, regardless of all these other things that government gives you. I don't think it's fair to use an individual in these kinds of situations as a social battering ram to try and get more public information to the public, or to try and fix the public prosecutor's defense system when we could do this in other ways that don't violate the individual's rights so much. Yeah.
Okay, so people absolutely can still choose private counsel for all of the reasons you just outlined. They just have an additional input into their decision that we think is perfectly justified.
I think at the point when there are already so many points pushing you towards this, adding another burden onto them and trying to force them into an already broken system just massively reduces their right to a free trial, never mind their right to not self-incriminate. And that's actually going to be my second point about why it's important to not have you incriminate yourself. Look, testimony at trials is just never about the facts of a case. It's often meant to build and present some version of your personality in order to feed to juries, and with questions that are mostly irrelevant to the facts of your case, but are about your personal life, in hopes of revealing some kind of scandal to discredit you, or to make sure that you seem discredited to the jury that's going to decide in favor of the prosecution. This may be questions about your past criminal history that has now been resolved. This may be questions about your extramarital affairs. The end point of this point is that it's particularly important how information is used to build a biased view of you to the jury. Why? Because it's this view of you that's always going to be about how the cases are decided, and I think this is the most fundamental reason why we allow people to not self-incriminate. I think there's a distinction here between mind crimes and thought crimes and crimes that you actually commit. I think it's unfair to charge people for how they're viewed by other individuals, and if we can reduce that by allowing people to not self-incriminate, then we're very happy to do this. I am very, very proud to oppose it.
I thank the member of opposition for remarks and invite the government to conclude the case for the government side.
When we have a justice system where it's easy to put away a helpless black person on a drug charge, but it's very difficult to put someone away for a white-collar crime that causes people to lose their life savings, I think we have a problem. I think that's the problem that Dhruva goes about trying to solve in our extension that we don't really get meaningful responses to from closing opposition. So I'm going to do three things. I'm first going to talk about our extension, the material we introduced, and why accountability is so important. Secondly, I'm going to refute the analysis we get from CO, and then finally wrap it up by addressing what OO talks about, though recognize the context Dhruva gives you does a lot of that work for me. So what do we hear in extension that we just don't get responses to? There's a lot of material Dhruva does to quickly go through. Many cases don't go to trial, so we're not talking about the poor people that OO talks about. That many people, we're talking about people who can afford attorneys, so we're not talking about the poor, helpless, victimized people, which also addresses some of what CO talks about. And third and lastly, we're talking about people where they would consider pleading the fifth in the first place. And this is the key point of the extension that we don't get a response to. That many people choose not to plead the fifth because as up and down the op bench, it looks optically bad. That if you're on trial for a sexual assault, you don't want to plead the fifth because that allows the prosecution to paint the narrative of you. Rather, you go up in your nice suit and nice clothes and you talk about how you want to be a minister someday because that's the least likely occupation to have committed the crime. We think that optically, not realistically. So the implication of this is that the people who would consider not pleading the fifth, or pleading the fifth, are the people who have nothing to gain from testifying, but everything to lose. That sets up the risk analysis that makes the consequential arguments Druva tells you about getting information about these people so important. The only real response we get is like, oh, maybe we should amend information laws. Like, maybe that would work against a bad extension, but Druva had an interesting material explaining this is the only way to do it. That oftentimes, one, this is the only source of information, you were the only one who knows what you were doing, and two, many people don't necessarily know, and that many people can hide resources. So we get, and also they say that it might be about drug cartels. That also applies because like you can't like subpoena the rest of the drug cartel that's in like the war-torn drug war area. I think like you need information. We get reputation that's like, oh, we don't even use this for information. It's just to paint a character picture of you. Like that's just false because many of that type of information is just objected out of court in the first place. Like we do want to get information from them. I think they have like a how to get away with murder type perception of how the justice system works, but that's not actually what happens. So what is the impact of this? And I think we actually get the impact from the introduction to the MO speech, which is that the point of criminality is you do it because you don't think you're going to get caught. That is the fundamental problem with our justice system, that people who commit the worst kinds of crimes and the most destructive kinds of crimes don't actually think they're going to get caught. On our side of the house, we give prosecutors more tools to actually do it. And they paint this fiction where they say prosecutors have tons of evidence, tons of resources, but even if that's true, the structural procedural system, the things like proving guilt beyond a reasonable doubt, the things like having access to many types of lawyers means that if you're able to pay the price tag, then you get the advantage against the prosecutor. It's like a threshold. The prosecutor has a lot of power asymmetry over the poor defendants, but it's very weak compared to the rich defendants, and this is the tool that we explain systematically is targeted towards addressing those people. We actually get accountability in those instances, which is the only way to make these crimes go down, because we actually increase the chance of the justice system to provide the deterrent. But also on a moral level, I think accountability for those that do something wrong is just as important as procedural rights, because when those procedural rights just become a guise for ignoring people, that becomes incredibly important. I'll take a few by. Yeah, sure.
Okay, so if you're of lower income and are on trial for something like drug trafficking or assault that may put you away for your entire life, you might choose to spend your savings to get a better defense at trial rather than settle. Why should you be forced to do so at the expense of your right to not self-incriminate?
Sure. So I think in those instances, you would want to testify in the first place because there's already a narrative against poor people that if they plead the fifth, they're probably guilty. So your lawyer, if they're a good lawyer, would probably advise you in the first place. I like to think that might happen in 1% of cases where they might want not to self-incriminate. That's not enough for you to win the round. Reputation of CO. So overall thematic idea, if they're going for the more principled parts of their extension, is they needed to show two things about the nature of this right. First, they needed to show it was an intrinsic right, that the only reason it applied to everyone if it has some independent value, something like free speech. But I don't think they do that, particularly because they don't refute OG's material about this idea that we only use this right because it's good for some outcome. This generally underlies many procedural rights in the justice system. We think things like search and seizure, we have them so that they're a safeguard against bad evidence. But we've given you analysis for why, systematically speaking, this will promote good utilitarian outcomes when we apply it as a rule, because the cases it's likely to apply to. The second thing they needed to show, though, was that procedural equality is more important than substantive equality. By that I mean the idea that just treating everyone the same in the law is more important than actually getting equal outcomes. But they never give us a reasonable response for why that's the case. And I think the reason why it's misguided is they don't account for the pre-existing power disparities in the system that allow some people to naturally get access to better protection in the system. We say we are accounting for that by recognizing that some people deserve access to this right and other people don't, because it balances the scale and actually gets accountability. Closing.
So what happens when you put all the rich people to the public defendants like you want to, and the public defendant system gets even more overloaded?
So I think you're giving us material for why they're probably not going to choose the public defender, but also recognize that, as we said, only about 5% of cases go to trial. We're not talking about that many cases in the motion, which means in this instance, a couple extra cases does not make or break the difference in the public defender system. If anything, it does what OG tells you about increasing lobbying for more resources. So then just on the last bits of CO, so that answers a lot of their rights extension. I've already answered the public prosecutor advantage. Now just on this idea of thought crimes, again, a lot of this information about testimony is just wrong, it'd be objected out of court in the first place. But also I just don't think you have a right to say that oh, I want to not tell people that I'm guilty. Because if you did something wrong, part of it is you should be held accountable. The reason we have this right is because of the fact that sometimes you might be misled by the court. That doesn't apply when you have a good attorney that can guide you on what to say. Then on OO. So on this idea that poor people, the narrative is now that they're all guilty. So I think the thing is that, like, if that's true, they can just choose not to plead the Fifth. And the answer to the POI is, oh, their public defenders force them to plead the Fifth. I don't think that's true because lawyers are beholden to do what their clients want. Like, these are things that they could get disbarred for. Or if the coercion is so strong, they'll be coerced either way. Like, I think the problem with this idea of the narrative is they needed to show that the narrative of pleading the Fifth means you're guilty does not exist now, and we change that. But that narrative already exists, which means they don't have a consequential impact in this debate. What's important is actually getting accountability for people who did something wrong. Only closing government tells you how we get that.
Yeah.
I thank the government for the remarks and invite the opposition to conclude this debate.
We wonder why the government team even wants to maintain the criminal justice system. Like, truly finding people guilty just to create a better precedent that actually helps create better society might just be a more optimal utilitarian stance. But what we say is, insofar as there are certain importances of individual rights, and not to make certain individuals social battering rams just to cure societal ills that aren't because of those specific individuals, is not sufficient analysis from the government. NT gave you a lot of analysis why that individual rights should outweigh. We think that closing government coming and say, that's not good analysis, utilitarian outweighs, without ever giving you a reason why utilitarianism outweighs, is probably just not good refutation. Two themes in this speech. First, individual rights versus collective right. Secondarily, is it really all about white-collar criminals? Not really. So we'll deal with closing government under that. So first, on the individual versus the collective. So let's deal with opening government right off the bat. Their big part of their case is that political will now exist to improve the public defender. First of all, we've already presented you alternatives to fix that public defender. For example, you can subsidize certain types of private counsel for criminal defendants that oftentimes tend to be charged. You can improve public defender through like subsidization. That's fine. But we think that the link of stating that all rich people may one day identify with the fact that they might be criminally charged and then give money to that public defender is very weak. Most rich people never see themselves being arrested or being criminally tried. Maybe like two Wall Street bankers might be like, well, one day I'll engage in embezzlement, so here, I'll throw some money into that system. But most people don't think like that, right? So it means that a majority of rich individuals, with the majority of political sway, likely will never invest in that system or ever create a special interest group to improve public defender systems, which means all their analysis about why rich individuals actually step in and improve the public defender is not a meaningful one, right? We think that so that deals with their case. But even if we're wrong, we think this is a wrong avenue to force defendants to actually necessarily become weak relative to the state just to make societal change. Why? I think this is a deal with the whole collective versus individual. They say, insofar as we create better precedents, we win. But placing a huge punishment upon an individual, for example, a life sentence, is quite a large onus to put upon an individual to create small societal benefits for the rest of society because most people don't benefit in the same way. Secondarily, you are arbitrarily selected solely because you might have been convicted or charged with a white-collar crime. Just because you're charged with a white-collar crime does not mean that you are any more guilty than someone who's charged for any other crime. So that means taking away a protection just to potentially guarantee a precedent that might be good is probably unfair to you as an individual because you were assigned a specific charge. Thirdly, we think even if that's all untrue, we think just creating a sense of justice that people can believe in the criminal justice system to actually serve their interests rather than trying to create the best political precedents might actually be something that's important for people. So if closing government wants to argue about optics, we think the optic of destroying political expediency and actually having some belief in the justice system is quite bad. So we think their analysis needs to go beyond saying the collective right is greater. We've given you reasons for why the individual right is actually important. But even if we can see the fact that worse precedents actually happen, we think, first of all, very few trials actually tend to create very large precedents, right? That means in 98% of trials, when you actually have people have their ability to not self-infringe on their own rights are taken away, most of those people are just going to get screwed and not actually create beneficial precedents. But even if we're wrong, we have to consider those individual protections against a collective benefit. I've already given you the analysis of why that's important. So then, here out of opening government, the only implicit response is, well, look, you make up for that because now you help to correct the asymmetry of power when you have private counsel. That's it's okay to take away this Fifth Amendment. First of all, we think that the state and the public prosecutors oftentimes will outpower you. Recognize the fact that DAs have way more resources than any individual ever will be able to possess. Why? First of all, they have plenty of resources to hire the best lawyers. There's a reason the DA office has massive amounts more money than the public defender system. Secondarily, they can hire and launch private investigations on you. Third, they have subpoena power to call on people in which you as a public defender and a private counsel don't. Fourth, they can choose who to charge and how long to charge you for. Insofar as those things are all true then, we think a private counsel is the only meaningful ability to protect against that state. We recognize the public defender system isn't great, but telling all individuals to resort to a system that necessarily screws them in a criminal justice system is not the way to solve that. We think a private counsel actually helps to protect you against helps you protect you and helps you to avoid a course of choice and necessarily being found guilty by the state is the only meaningful way to protect against that state. We think enshrining a right that allows you to protect yourself insofar as the Fifth Amendment does that, we think should allow you to do that, because that makes your defense more equal and allows you to outweigh against the power of the state. No. Secondarily, is it really only about white-collar crime dealing with second government's extension? So really what we hear is, look, you stop white-collar crime because firstly, it's just all about white-collar crime, but secondarily, they give you like 3 reasons why that happens. First of all, we question the premise of this case, right? Because it's unclear that only bankers access this right. Why? Because most rich individuals turn to things like private arbitration to solve. Secondarily, these crimes are oftentimes very hard to actually bring to trial. If that's all true then we think a majority of cases actually tend not to be about white-collar crimes, but even if that's not true, we think outweighing and telling everyone else who's not a white-collar criminal who hires private counsel that their necessary ability to access defense is infringed upon is probably an unfair thing to place a burden upon them. Go.
If the legal system can never treat people differently, would you get rid of things like mitigating factors for people with mental illnesses which they have no control over, or things like immunity for sitting heads of state?
Okay, no, okay. If we're granting more protections to defendants to protect them against the arbitrary power of the state, we think that is good. That is what we're trying to tell you, that private counsel can never outweigh. But if you increase the power of the state, who already significantly outweighs you, which is what you're doing, we think that is a significantly unfair thing to place upon defendants. We think that just creates a more coercive element of a justice system, right? So, look, what type of questions are asked in these testimonies? What type of things are you going to be forced to answer to? Because closing government says the only time people turn to the Fifth Amendment is to protect themselves against getting on emails or convict them, right? No. Oftentimes the questions that are asked when you are testifying is, what is your past criminal history? Or questions that might pertain to the case that might actually make you look bad, but don't necessarily prove you guilty. These are strategic tools used by lawyers to prevent juries from finding you guilty. Insofar as that happens, we think people should not be forced to answer those questions in manners that negatively hurt them, even if that means that sometimes you don't get to ask the questions that might necessarily just immediately solve the case. What you have to weigh in this debate is it fair to force individuals who've never actually committed a crime to necessarily harm themselves in cases just because you might catch 2 more criminals and create 1 good precedent? We don't think it is, right? Also, we think there are ways to mitigate closing government's extension by creating better information and discovery laws. But we think taking forced testimony from those individuals is unfair. What do I mean by better information and discovery laws? You could probably just ask that corporation to reveal their emails in a way that already exists. So we think that all the mechanisms they give you probably just aren't fair. But again, we tell you we outweigh on that. So why have we won this debate? So why do we come over opening opposition? We think, you guys are the 2, you guys are great. We think while a lot of their analysis is great, we take the analysis a lot deeper, tell you why the individual right is important. We've told you why the utilitarian calculus is not sufficient. By the government team, we told you why individual rights should be protected. Why do we be closing government? Because they hinge their hat on the fact that only white-collar criminal cases matter. They don't tell you why those are the only meaningful cases and why that should outweigh every other criminal defendant who ever accesses private counsel who may actually want to exercise the right to the Fifth. Why do we beat opening government? Because we told you their political will argument is actually just insufficient, and also their entire case about precedence is A, severely overblown, but secondarily, not enough to outweigh the individual rights and protections of 90% of the other cases that matter. For those reasons, incredibly proud to have us.
I thank all sides for next debate. Invite them to cross the floor, shake hands, and we will get to the other